Before I introduce Sophia, I will say a few brief words about CFAs. I'm sure it won't have escaped your attention that they're of relevance to this case, and in particular the question of success fees. So CFAs have been with us, as you know, for many years, and their enforceability is dealt with by the Courts and Legal Services Act of 1990. And I just wanted to remind you briefly of a couple of the provisions in that act. So section 58 is the relevant section, and section 58A. And we all know what they are, but it's the definition, if you want it, it's found in section 58 of the Act. A conditional fee agreement is an agreement with a person providing advocacy or litigation services which provides for his fees and expenses, or any part of them, to be payable only in specified circumstances. And then you also know that there are provision for success fees as well. But since the Jackson reforms of 2013, you will know that a costs order made in proceedings may not include provision requiring the payment by one party of all or part of a success fee payable by another party under a conditional fee agreement. And I think when I began to think about, I found out about the Re-H decision and I began to think about this, I thought, well, why hasn't this been dealt with before? That provision's been with us since 2013. And we know that a lot of 75 Act applicants enter into CFAs with success fees. But there we are. As Sophia is going to tell us, the judge hearing the trial had only two previous authorities to consider on the point, and nothing at appellate level. Anyway, that's enough from me for now. I am going to welcome Sophia now and hand over to you, Sophia.
Kate. Hi. Well, yes, I pick up on that point that you just made, that there are a lot of CFAs used in 75 Act claims. So this case is going to be of importance to a lot of people and a lot of cases. I think part of the reason we use CFAs so frequently in 75 Act claims is, of course, particularly in maintenance claims, we're dealing with litigants that are in financial need. So often it may be the only way that people can fund their litigation. There were only two previous authorities on this topic before the case came before Mr. Justice Cohen at first instance. And it is surprising, given how significant it is an issue, that this hadn't been dealt with previously. And those two authorities were conflicting. So this judgment from the Court of Appeal clarifies exactly what the position is for us. I'm just going to quickly share my screen because I have some slides. So let's see if I can move us along. What were the facts? So this was an adult child claim by a daughter against father's estate. Dad had a will. He left his entire estate to his wife. There were two children, my client and a brother. The brother was the personal representative of Dad's estate and represented the estate in that capacity during the proceedings. My client's circumstances were these. She was 50 years old, had two children. She was in financial need. We said and gave evidence that she had a housing need. It was recorded in the judgment that she was living in local authority accommodation, which was plainly less than ideal for her circumstances and the family. She was reliant on state benefits, including universal credit, and there was an income shortfall. In particular, an income shortfall in relation to the universal credit, because my client suffered from severe mental health disorders, which meant that her partner couldn't stay overnight in the property with her and the children. And of course, when the universal credit was calculated, that took into account his income contribution to the household, which actually had to be used on separate accommodation for him. Her mental health disorders were, I think, quite a weighty consideration in the claim. There was an expert report saying that she really required 3 years of therapy. Her disorders meant that she wasn't able to work, but hopefully after those 3 years, she would be better placed to get back into the workplace and start to earn a living to support herself. The other key feature of my client's position was that there had been 10-year estrangement from her parents, albeit they had actually financially supported her until quite an age. She'd stayed at home until the age of 30, and then they supported her again for a further period of 3 years while she did an MA at university sometime later. but in the last 10 years, up to the date of trial, there had been estrangement. The defendant's circumstances were these. She was the wife of the deceased, 80 years old, profoundly deaf, in ill health and residing in a care home. The deceased had actually died in house fire, and I think, which was the matrimonial home, and I think that led to the defendant moving into residential care. But we heard during the trial from her son and also a care home worker that it was impossible now for her to be living independently. She would be in a care home for the rest of her life. But we were quite limited in the information we got about the defendant's circumstances, in particular because she was subject to sanctions. And this is relevant to one of the grounds of appeal. She had been previously represented in the proceedings, had solicitors and counsel at a previous CCMC. However, she was subsequently declared to have been automatically debarred from participating in the hearing and from relying on written evidence under CPR 8.4 and 8.6. These proceedings went on for quite a long time. They started in 2017, and we'd agreed repeated stays and extensions of time for the defendant to put in her acknowledgement of service and evidence, and she never managed to meet a deadline. Therefore, by the time of trial, she wasn't allowed to participate in the hearing or rely on written evidence. What was in the net estate? So the sole estate, or the estate in the deceased sole name, was relatively small. It was £141,000 in a bank account. It was the joint assets that he owned with the defendant that were of great value. So we said we will make an application under Section 9 of the Act such that the deceased's severable share of those jointly owned assets will be included within the net estate. And the judge agreed to do that. And he found the total estate to be in the region of £554,000. There is a comment in the Court of Appeal judgment that I would like to clarify, where it says that the claim exceeded the value of the estate. In fact, the valuation of the home went down just before trial. So previously, on previous valuations, the claim didn't exceed the value of the estate. But I think this trial happened in April 2020, and I think the valuation was just before, right at the beginning of the pandemic, before we had stamp duty holidays and things like that. So we believe that that impacted the valuation, brought it down just before trial. So what happened at trial? Well, this was it was the first remote trial or hearing that I did. It was right at the beginning of the pandemic, so it happened remotely. The defendant was in her care home, which obviously made things difficult in terms of communication. Nevertheless, my solicitors were praised a lot in the judgment by the Court of Appeal for the lengths to which they went to try and make sure that the defendant had all of the information that she required to attend and understand what was going on in the hearings, notwithstanding the fact she was debarred from participating. We served disclosure, we served evidence, we served the trial bundle and liaised with the care home to make sure that things would be available to her, and that a computer in the office of the care home would be available to her when the trial took place, and that someone would be there to sit with her and pass her notes so that she understood what was going on. And the judge spoke with the care home worker at the beginning of the hearing to check that she'd be there throughout. We had the trial, and Mr. Justice Cohen said this in his judgment. He said, balancing all of the Section 3 factors, there were various priorities that he wanted to meet. The first was that he said the defendant needed to be able to meet her care home costs for the rest of her life. And we had some idea of what those were because the defendant had lodged a letter in the couple of days before trial with the judge, setting out, I think, what can only be described as her opposition to the claim. She then also made some submissions about what her financial needs were in relation to care home fees through her care worker at the beginning of trial. The judge said also that the claimant having been financially independent of her parents was very important, and the estrangement, but that ultimately her priority need was to get well again, to recover her health and be financially supported over the 3 years that that was likely to take. And that last bullet point really is what informed the judgment and how it was structured. So this was the award. Sheila, my client, was awarded £138,918, which included a lump sum for the 3 years of therapy and psychiatric oversight, a lump sum to cover income shortfall over those 3 years, a lump sum for a top-up for the loss of universal credit, which she would suffer as a result of having been given the first 2 lump sums, a lump sum for replacement white goods and a car upgrade, £10,000 towards accommodation expenditure. And the thing that's attracted most attention about this case is that she received £16,750 as a 25% CFA uplift. So what did Mr. Justice Cohen say about the CFA success fee issue? Well, Kate, I think you've already just taken us through in the introduction, section 58A of the Courts and Legal Services Act 1990, which provides that a costs order, let's look at it one more time, a costs order made in proceedings may not include provision requiring the payment by one party of all or part of a success fee payable by another party under a conditional fee agreement. And as we discussed, there were just two authorities on this before the hearing. The first authority was Ree Clark, which was the case by Deputy Master Linwood. In that case, he declined to make, at the request of the claimant, a contribution towards the party's success fee. He seemed to do so for 3 or 4 different reasons. The first was that he said it would be contrary to this legislative policy found under section 58A6. He also said that, interestingly, he referred to damages claims. I think those that practice in 75 Act claims know that this is far from a damages claim. 75 Act claims are really quite unique in civil litigation in that you're making an award. The court has the statutory jurisdiction at its discretion and making a value-based judgment to make an award for someone's financial needs, which is much more akin to what happens in divorce proceedings, financial remedy cases. But nevertheless, Deputy Master Linwood said that calculation of damages is a matter of procedure carried out before costs and has never included an element of costs. He also suggested that allowing success fees in 75 Act claims may put a CFA funded litigant in a better position in terms of negotiation. And finally, he said that it would put a claimant in a 75 Act claim in a better position than a claimant in, say, a personal injuries claim, again referring to damages type cases. We made various different submissions in response to that. Kate, I don't know what you think. People have expressed views on all of these arguments.
In terms of which sphere, which particular?
Well, should we talk about first the idea that it would be contrary to legislative policy? I think what we submitted to the Court of Appeal was to say that whilst there's this policy argument, it's Deputy Master Linwood didn't say how that overcame the requirement of section 3(1)A of the Act to take into account a person's financial needs. And a CFA uplift is a debt, it's a contractual liability that is not recoverable in any other way, by way of a costs order or otherwise. So our submission, and the Court of Appeal have agreed with it, and Mr. Justice Cohen did, is that it's under section 3(1)A of the Act, you have to take into account financial needs, and therefore the court is obliged. The court is simply obliged to take into account the fact that a claimant has a success fee liability if an award is made.
Yeah, I mean, that's at the heart of what the Court of Appeal has decided, isn't it? The wide-ranging ambit of the 75 Act, which requires the court to consider the claimant's financial circumstances at the date of the trial, it is wide enough to include debts, and that's been decided in previous cases. That debts can constitute, that payment of a debt can constitute reasonable financial provision. So it did seem that there was no other place for the Court of Appeal to go on this question. I know that a lot of people are concerned about underlying tensions between costs orders on the one hand, funding on the other, and the type of the discrepancy with matrimonial proceedings that I know you'll perhaps go on to talk about. But in terms of that basic question, is a claimant's liability for a success fee a debt? Question 1. And question 2, can debts be included in 75 Act orders? As I said, it seems to me that there was no place for the Court of Appeal to go other than to decide that. But there's a lot of nuance that no doubt you'll go on to talk about whether a court's always going to give you provision for your success fee, how much, you know, could you have got your funding, could you have funded the case other than by a CFA? I'll stop talking because I know those are some of the things that you're going to go on to talk about.
Well, certainly when I get to the Court of Appeal decision, we'll talk about those points. I mean, one thing that we also submitted from the Court of Appeal was, in response to this policy type argument, is it's very, very clear from cases like Eyelet. I think actually Lady Justice Black, in one of the couple of different visits to the Court of Appeal, I think said specifically that it's not right to put a gloss on the statute. The 75 Act is very broad in terms of the Section 3 factors. Section 3.1a and Section 3.1c just provides that you need to take into account all financial needs. So it's not right to restrict or seek to amplify or prescribe what counts as a financial need under the Act. It's very clear that it does include debts, it includes any type of financial need that needs to be taken into consideration. But one's not always, in the words of the Rolling Stones, you can't always get what you want. You're not always going to get all of the provision that you have asked for anyway, because the court has to balance all of the Section 3 factors and work out what's reasonable in the circumstances of each individual case. Okay, well then, should we look at the second authority, which was Bullock and Denton? Bullock and Denton actually came out, I think, 4 days before our trial in Re-H. I think it only came to our attention because we spotted it on LinkedIn. Someone had posted the unreported judgment, which was very useful because we were able to rely on it in this case. There, His Honour Judge Gosnell had decided in the other direction, and he'd said, I am going to make provision for a success fee in this award. It doesn't appear that he had been referred to Re-Clark, so he came to the matter afresh and very much repeated the types of arguments that we've just looked at, that Section 3.1a required him to take into account financial needs. A success fee is something that cannot be recovered by any other means, and there is a risk that it could undermine the award. And I think that's really the point, Kate, isn't it, that is made in cases like Lillyman, when you were talking about base costs as well, that what we do in 75 Act claims and what judges do is really carefully scrutinise the financial needs of the parties, particularly maintenance claims, and work out, sometimes to the pound or penny, how much is required to meet various different needs. And so when it comes to the uplift, if the court is willfully blind to this sometimes very large financial liability in the background, as Deputy Master Linwood would have it, it risks undermining the whole judgment. If you've carefully provided a fund for housing, a fund for income, and you're just going to deliberately ignore something in the background that's going to undermine and reduce that award and take away from the purposes for which it was intended, then surely that doesn't make sense. It's not a realistic approach.
Yeah, I mean, I'd agree with that, but I think where the tension is that, for example, you can identify and quantify a success fee, and the court can take a view about how much is going to be accommodated in the award or not. But that doesn't altogether, I think, overcome the tension that's now apparent increasingly in a lot of these cases where a claimant is going to be presumably liable ultimately to pay the irrecoverable element of the costs. So they'll get a costs order in their favour. They've won the case. They've got an award, but there will be some element of their base costs, presumably in most cases, that they simply won't be able to recover from the other side. That's a debt that's not yet capable of quantification, I don't suppose, at the date of the hearing. So at what point do you stop? Are we going to see, do you think, applicants now asking for irrecoverable base costs as part of their as part of their award? So
this is something that I am going to come on to.
Sorry,
no, you're getting ahead. That's exactly what Lord Justice Briggs, or Mr. Justice Briggs, as he was then in Lillyman, was saying about base costs. And it is interesting. Re-H and Hirachand in the Court of Appeal are about CFA uplifts, so that's completely different to base costs. But it will be interesting to see if something, if anything, develops either through Parliament or in cases with regards to that. But I'll come on to speak about that in a minute.
Yeah, I'm keen to hear your views on that, because in the eyes of an applicant, it might be a future debt rather than a present debt, and why should they feel that it's fair to have one and not the other? Anyway, I'm going to shut up because you need to tell us more.
Well, so ultimately, Mr. Justice Cohen had considered both of these authorities, and he said, no, I am going to make an award in respect of a contribution towards the claimant's uplift liability. And he said this. He said, I accept that it is appropriate for me to consider this liability as part of C's needs. I do so largely for case-specific reasons. I'm not making a large award, unlike in Re Clark. It is not an award that permits of much elasticity. If I do not make such an allowance, one or more of C's primary needs will not be met. The liability cannot be recovered as part of any cost award from the other parties. The liability is that of C's alone. She had no other means of funding the litigation. These last three sentences are quite important because really they reflect exactly what the Court of Appeal said in its judgment. So he really did get it right, is my view, Mr. Justice Cohen. He carried on, he said it would not be fair on the claimant for me to ignore completely her liability to her solicitors, but I recognise that there is a risk of injustice to the estate, in particular if an appropriate Part 36 offer had been made. I cannot see how I can avoid some potential, and it is only potential injustice, to either the claimant or the estate. All I can do is mitigate the potential by taking a cautious approach towards this liability. I propose to allow the figure of £16,750, which approximates to a 25% uplift. And this, Kate, is I think the point you were coming on to, in the sense that he mentioned Mr. Justice Briggs' judgment in Lillyman. There's Lillyman substantive judgment and also a costs judgment, which is relevant to this issue about base costs and 75 Act claims. In that, as I say, Mr. Justice Briggs wasn't dealing with CFA up to this point. He was more considering this idea that you carefully structure your award under the Act and a wrecking ball can end up being thrown through it by reason of a decision on the costs at the end of the day. He said this, I must in concluding express a real sense of unease at the remarkable disparity between the cost regimes enforced on the one hand for Inheritance Act cases, whether in the Chancery or family divisions, and on the other hand, in financial relief proceedings arising from divorce. In the latter, my understanding is that the emphasis is all on the making of open offers and that there is limited scope for cost shifting so that the court is enabled to make financial provision which properly takes into account the parties' cost liabilities. In sharp contrast, typo there, the modern emphasis in the Inheritance Act claims. And then he went on to explain that we follow the civil cost regime, which is very different, wherein people do make cold bank offers. And the court doesn't have all of the costs information usually before it at the time and has to make a decision after the event. This is interesting. I say this comparison between financial relief proceedings and Inheritance Act claims, which are a creature of the CPR, because it's a theme that runs through not just Cohen's judgment, but also the Court of Appeal judgment in regards to base costs. He carried on and said, the judge then went on to observe that the potential for negotiation offers to undermine a judge's attempt to meet needs is a disadvantage to the sole litigation cost regime. It was, of course, for that main reason that making of cold bank offers in matrimonial financial remedy cases was outlawed. What I found really interesting during the trial of Re-H at first instance was Mr. Justice Cohen, really experienced family division judge, actually had quite a conversation. We had a discussion during submissions about this and the difference between costs in financial remedy proceedings in the family division and 75 Act claims. And of course, there aren't CFAs really in the family division. They don't make cold bank offers. There's an order, the general rule on costs in financial remedy proceedings is that no costs will be recoverable by way of cost order against the other party. So effectively no order as to costs. And therefore the family court can take into consideration everyone's cost position, which is all open, and make provision for it in the award. Whereas because 75 Act claims are part of the civil cost regime, we are used to dealing with base costs after the event. And there is a peculiarity to that, I think, when you're dealing with 75 Act claims, because they are so similar to relief on financial remedy proceedings. Section 25 of the Matrimonial Causes Act is so similarly drafted, and it's such a similar statutory jurisdiction that's being exercised to Section 3 under the 75 Act. It'll be interesting to see whether whether there will be any development either from Parliament or otherwise.
Yeah, I mean, sorry, just butting in there, Sophia. I wonder, being slightly controversial, is there scope, for example, for the courts for Parliament deciding that spousal claims in 75 Act cases should move over to a more matrimonial cost type regime? Just throwing it out there. Don't know what anyone else thinks. Feel free to populate the Q&A box.
I haven't checked on the Q&A box yet.
I've been checking. We've got a couple of questions, but I'll come to those later on. But you know, with this tension, I wonder, and given that certainly in spousal 75 Act claims, there are many similarities with matrimonial financial remedy, that I wonder whether we're going to see some sort of fusion in future.
We were asked in the Court of Appeal during submissions about this point. I mean, Hirachand is about the CFA uplifts, which are different. So it wasn't so much about this, but it's of interest to the court, I think, the base costs issue. And I think my leader was asked, you know, well, what about irrecoverable base costs? Why don't people as a matter of practice ask for those as part of your substantive award under the Act? And I think Constance's response was, well, in theory, you can't really see why not. It's just because there is a civil cost regime which provides for costs to be recovered and an appropriate assessment of them. There's no need, it would appear for practitioners, or at least practitioners must feel that there's no need for them to ask for the costs within the substantive award, which is different to the CFA uplift because there is no way of recovering that by way of costs at the end, pursuant to and by virtue of Section 58A of the Courts and Legal Services Act. So it's just an interesting, I think, side point to re-H to see what could happen with regards to base costs as well. Okay, so what happened in the Court of Appeal? How did we get to the Court of Appeal? So, well, what happened was Mrs. Hirachand, the wife of the deceased, the defendant, decided to re-instruct solicitors and counsel, and they sought permission to appeal Mr. Justice Cohen's decision to the Court of Appeal. They had various different grounds, I think ranging to about 5 grounds, including attacking the quantum of the award, but they only originally received permission to appeal on ground 2, which is that the court erred in law when it made an order for financial provision in favour of the claimant, which included a sum referable to a contribution towards the CFA uplift liability. They then made an application under CPR 5230 to reopen the permission decision and managed to get permission also on ground 1, which was this, that the court erred in proceeding with a trial by video link when, by reason of the defendant's disability, being profound deafness, and residence in a care home which was closed to outside visitors due to the COVID-19 crisis, the defendant was effectively denied access to the trial. So should we look at ground 1 first? You'll remember that I said before that Nalini, the defendant, had been debarred from participating in the hearing or from relying on written evidence. Well, her counsel argued that the judge should have adjourned the hearing to a future date for an in-court hearing, I think in person, and at which she could be provided with some support additional to that their care home staff had given her. They also, I think the Court of Appeal commented on that, really, that because of the nature of the defendant's deafness, it wasn't the case that other adjustments that might be appropriate for deaf people would have assisted Nalini. For example, she couldn't sign. It seemed that at most it would simply have been a different person to have attended court with her to pass notes to her. It was said that her attendance must be meaningful, although it wasn't completely clear what the definition of meaningful would be. And they also said that she should have been able to make submissions in respect of the costs order, and that there should be a retrial of the costs and the CFA issues. The Court of Appeal noted correctly that actually the costs order was never appealed. It was subject to a separate judgment on a later date at consequentials. So there certainly wasn't going to be a retrial of costs determining the costs order. What was also interesting was that The defendant had never applied for application, she'd never made an application for relief from sanctions, and it was never even suggested on the appeal that she would. So really what the appellant was asking for was a retrial at which she would still be debarred from participating, and at which she would have to make an application for relief from sanctions. On that point, we said that, well, surely if I'm making that application, there's going to be quite a big wasted costs element to being granted relief, because this application should have been made at the trial, and now we've incurred the full costs of the first trial thrown away. So such application would be very difficult to mount anyway. In response to the substantive points, we relied on authorities on vulnerable and disabled litigants, including CPR Practice Direction 1A, Participation of Vulnerable Parties, and the Equal Treatment Bench Book. I have to say that I was not familiar with Practice Direction 1A until this case. It's really short, it's a page in the white book, so I think people could miss it. I don't think people are necessarily even aware of it, but it's really useful to have a look at that. The equal treatment, these are my tips to take away that I've learned from REH. The Equal Treatment Bench Book as well I became familiar with, and it is really a book for the bench, for judges, to guide them on the types of reasonable adjustments that are available from the court for people with disabilities, and the types of things that they should be considering and taking into account in the conduct of a trial and conduct of cases. But actually, it's really, really useful guidance for practitioners, whether it's your client that has a disability or one of the witnesses, or particularly if you're in a case like REH where it's the unrepresented litigant in person on the other side that has difficulties. The bench book provides lots of examples as for, in any type of situation or difficulty that someone is facing, the types of things and services that are available that can assist. We also said that the actions of the judge at first instance and my instructing solicitors did everything possible to afford the defendant the opportunity to attend, and she could have made an application for relief had she wanted to, particularly given that she'd written a letter to the judge anyway, making submissions which was taken into account.
Sophia, are you able to enlighten us as to what your solicitors did? Because I noted from the judgment that the Court of Appeal were obviously quite impressed with the provision that the steps that your solicitors had taken. I must say it's always been my view that when dealing with vulnerable or debarred parties, it's always best to do slightly more than than the rules actually tell you need to. Yes, debarred means debarred, but I think to facilitate attendance at a hearing for a debarred party that would be certainly my tip. Do slightly more than you need to. It sounds like your solicitors did quite a lot to help the debarred party. Can you? I think our audience will probably be assisted by knowing a little bit more about that.
Of course. So, well, as a starting point, we made sure that she had everything made available to her such that she could attend, although she couldn't participate. We weren't obliged by court orders to serve her with anything further in the proceedings, but we did. My instructing solicitors, as I said, I think previously, served the disclosure, the evidence, the trial bundle, liaised directly with the care home and the care home staff. For example, there was a point where we were concerned about sending papers anyway, because it was at the stage of the virus where people were worried that it could even be carried on documents. So we were liaising with the care home to see whether electronic documents could be sent by email and put before the defendant. There were, I think, numerous telephone conversations with the care home actually in order to make sure that Nalini had access to a computer, that there would be someone there that could help her throughout the hearing and pass her notes. And as I said, the care home did provide that computer. I think Nalini was in the care home office, and the judge was able to then speak with the care worker at the beginning and make sure she could be there for the whole day. And Kate, you're right, the Court of Appeal, I think, made the point that really my solicitors went above and beyond what was required of them to make sure that Nalini had every opportunity to attend. And I think, of course, it's certainly right to make sure that everyone, particularly people in a vulnerable difficult position, have the ability to attend. But from a litigation perspective as well, not so much in this case, but certainly if you're going to go into trial, if you know that one of the witnesses is going to have an issue or is going to need reasonable adjustments made for them, it makes sense for your own client to make sure that you think about that ahead of time, that you communicate with the other side. These types of issues are things on which, particularly if the other side are represented, however hostile the proceedings, you should be able to have reasonable correspondence over it and come to an arrangement to make sure that the matter can go ahead. The last thing you want to do, or to be in a position of, is first day of trial and realise that you're not ready because various different adjustments need to be made and the court hasn't been put on notice. I think what I'd suggest is the best time to look at this is at a CMC, at a directions hearing. When you're thinking about your directions up to trial, that's the time to think about whether anyone has particular needs that need to be addressed, if not before that hearing. So yeah, I think, unless Kate, you've got any other top tips.
No, I mean, I think you've covered the point. As I said, do slightly more than you need to is often a good rule of thumb. What's not to like about getting recognition and thanks from the court for doing a little bit above and beyond, not obviously to things that are going to involve a significant expense that you don't actually need to. I think there's a balancing act to be performed. Yeah. Anyway, look, you probably want to get on to ground 2 now.
Well, quickly, I'll say what the Court of Appeal found on.
Oh yeah, do. Sorry.
I think people probably know. Effectively, the court dismissed this ground on the basis that Nalini did have the opportunity to attend the hearing, but importantly, they made some comments about participating parties versus attending parties. Firstly, they said there's no merit in the ground about it having happened by video link because the defendant was in no worse position than thousands of other people who've had to conduct their cases remotely. The court said that debarring orders should mean what they say, and a litigant who is debarred as a consequence of their own failure to comply with the rules cannot expect nevertheless to be entitled to have made available to them all the proper and carefully developed protections which have been put in place over the years to ensure that a participating party can put their case effectively. There's no obligation on a court to proactively manage the attendance of a debarred party, but judges, of course, have a discretion as to allow them to make submissions or to make special measures for them. Okay, so moving on to ground 2. What did the Court of Appeal do? Well, first it noted that there's been a succession of cases emphasising not only that maintenance should not be defined too prescriptively for the purposes of the Act, but also the payment of debts form a legitimate part of a maintenance award, and that's Eilert and Mitson, as well as other cases, I think. Inree Jennings is another example. The court commented that section 3.1a requires the court to have regard to the financial resources and financial needs which the applicant has or is likely to have in the foreseeable future. And it said the term financial needs is unqualified and unlimited and can include a payment of a debt. The court considered that those two conflicting authorities that we spoke about. It considered the dicta of Briggs and Lillyman, and interestingly drew comparisons to the financial remedy proceedings on divorce, in particular, noting that in financial remedy cases, outstanding costs which could not otherwise be recovered as a consequence of the no order principle in those cases are capable of being a debt, the repayment of which is a financial need pursuant to section 25 of the Matrimonial Causes Act. So in other words, as we were saying, Kate, in the general rule in family cases is that you can't recover your costs from the other side. No order as to cost, so the court has decided that, well, so far as you can't get them from the other side, then they are a debt, which we can take into consideration and make provision for on divorce. And Lady Justice King said that in her judgment, a success fee, which also cannot be recovered by way of a costs order, but by virtue of section 58A6 of the Courts and Legal Services Act, is equally capable of being a debt, the satisfaction of which is in whole or part a financial need for which the court may in its discretion make provision in its needs-based calculation. But she gave a very important warning and some guidance on this decision. She said, having said that, I should make it clear that it will by no means always be appropriate to make such an order. It is unlikely that an award will include a sum representing part of the success fee unless the judge is satisfied that the only way in which the claimant had been able to litigate was by entering into a CFA arrangement, and consideration will no doubt be given to the extent to which the claimant has succeeded in his or her claim. Further, an order will only be made to the extent necessary in order to ensure reasonable provision is made. So I don't know about you, Kate, but I think this makes it very clear that Hirachand isn't just the green light to get your whole CFA success fee paid from the estate. And I think it also lays to rest a concern that I think Deputy Master Linwood had in Re Clark. When you read that judgment, he talks about how he would have to be transferring the CFA liability to the defendant. But in fact, that's really not what's happening here. It's not about cost shifting. It's not about shifting the CFA liability over. It's actually about basically thinking about the Section 3 factors, applying the normal test under the Act that's been set out in Eyelet and other cases, that balancing exercise between the Section 3 factors, but just taking into account the CFA liability, the success fee liability as a financial need for which provision can be made. But the court is going to take into account these types of considerations as to whether to do that or not.
Yeah, I mean, I agree. It's difficult though, isn't it? I'm going to come to a question that Ryan Taylor has asked us in a minute, actually. Hi there, Ryan. Because I think you think of, I've had cases, for example, where the applicant has a credit card debt or more. The court seems, I've never had a case where the court has decided that only 25% or 50% of the credit card debt should be paid. I've had cases where the court said, yeah, well, as part of the reasonable provision, we'll clear those credit card debts because otherwise you're going to be using your income to fund repayment of that debt. Whereas that, you know, taking the same approach with the success fee brings me on to Ryan's question, because he says, what do you think of the 25% success fee figure? Do you think it will be used as a yardstick on future cases? And do you think claimants will be able to argue for more in larger estates? You know, we wouldn't be thinking of percentages. I think if we were looking at the court, whether or not to clear a credit card debt. What do you think about that, Sophia? So
I thought about that, and when I'm reading the judgment, whether it's only a contribution you're ever going to get. When I read the judgment, I felt that they weren't discounting the possibility of awarding someone the entirety of their CFA success fee. It seems more likely from reading the judgment and the decisions we've had so far that you're going to get a percentage of it instead. And I think it would depend on a case-by-case basis and analysing the facts of any individual case as to what you get and applying these factors. So one of the factors we can see is it's unlikely you're going to get an award unless the claimant had been able to litigate the proceedings by no other way than a CFA, and consideration will be given to the extent to which you've succeeded in your claim. I think some people's concern is that an unmeritorious claim or a very low value claim could be pushed all the way to trial because it's on a CFA and there's a belief that the uplift is going to be awarded. But I think it's really, really clear here from Lady Justice King that that's not the case either. That if you've had a very low value claim that really you shouldn't have pushed all the way to trial, then it looks like that is something in terms of success. I think that will have an impact on the amount of uplift you're awarded, what kind of contribution, if any. There's actually a recent case that's handed down last week where Higgins and Morgan, I think, by His Honour Judge Coulson QC in, I think it's Manchester or Birmingham, and he, I think he gave his judgment applying Re-H, but actually handed it down just before, I think on the same day or after, oh that's it, I think he'd circulated his judgment amongst counsel after Re-H, but then it ended up being handed down after the Court of Appeal decision, which he hadn't seen when he was drafting the judgment. But in any event, he again gave a contribution to the uplift as opposed to allowing the full success fee to be part of the award. So that might be the trend.
Yeah, and how do you think, this is a question from Lewis Hasty, which is a good question. How do you think CFA recoveries will be handled in 75 Act claims which involve settlement of property, such as a life interest, where there's little cash in the estate? So where there's not much cash to be able to accommodate much of a success fee. I suppose, I mean, my thoughts on that are in considering what's reasonable in all the circumstances, the dilemma for the judge there would be whether assets in the estate had to be liquidated purely for the purposes of helping to pay for a success fee. And if it was important to give the applicant a life interest in property and then there was nothing left over, well, I suppose the answer there is that you probably won't get much provision for the success fee.
Yeah, I agree. It's just like any case, the provision that everyone receives is often dependent on the value and size and nature of the net estate. We've all had 75 Act claims where the claimant's in financial need, but so are the beneficiaries, and there's just simply not a large enough estate to go around. So I think that's a similar issue, isn't it?
Yeah, I guess I think it is. I think it is. What about, I've got a question in terms of thinking about negotiations, and then I'm not sure how much you've got to go through yet, Sophia, so I won't turn to all the questions yet. We've had quite a few and I'm not going to be able to have a chance to go through all of them, but I was interested to hear your thoughts on does the prospect of being able to recover some or all of a success fee give an applicant an advantage in negotiations, do you think?
I'm not convinced that it does give much more of an advantage to claimants over and above what they already have in 75 Act claims. What we need to remember about Hirachand is it's really just identified the CFA success fee liability as a financial need. It's a debt. So just like any other financial need, it needs to be taken into account under section 3(1)(a). So when you're in negotiation with a claimant, they'll often be saying they've got lots of different financial needs, that they'll have a housing need, they'll have an income need, some other kind of need. And now, well, I also need my success fee, a contribution towards my success fee. It's just another string to their bow. I think should be treated quite similarly. If you don't think they've got very good prospects of success at recovering that, or even in the claim, then I think that informs the negotiation like it always would. I actually don't have much more by way of slides, and I think given time it would be quite nice for us to focus on the questions as well. So should I quickly whiz through these, and it might go to some of the questions as well?
Yeah, I've got I'll just quickly, there was Fiona Campbell-White asked a question about Part 36 offers fairly earlier on, so that I don't forget that, Fiona, I'll come to your question now, which I can answer. You have asked if a defendant makes a Part 36 offer to a claimant whose solicitor is acting under a CFA and the claimant accepts the offer, is the defendant only liable for the claimant's basic costs, not the success fee? In other words, can you recover success fees in Part 36? I think the answer to that is that under Part 36, the cost consequences is that you'll be entitled to your costs of proceedings. But there's quite a useful note in the White Book that tells you what's deemed to have happened is that a costs order is deemed to have been made on the standard basis, and that's what you're entitled to. So it won't include a success fee, because they can't be recovered in costs orders in proceedings. Sophia, I think we've got we had some other questions that we were thinking about, didn't we? One sort of procedural question is whether in your case it made a difference that the claim at first instance was undefended.
And this is something that people have asked me. I think obviously if you don't have someone on the other side to you, it may well make a difference, but I'm not convinced that actually it would have made much of a difference to the decision that Mr. Justice Cohen made, because we did have some information about Nalini's financial position, not an awful lot obviously, but notwithstanding the fact she'd been debarred from relying on evidence, on written evidence, the judge did have regard to a letter from her and information from the care home about how much her care fees were per year, and we agreed that the judge should take the figure that had been quoted by the care home as the appropriate figure. He was therefore also being made aware by the care home as to Nalini's health issues. my client believed that the defendant had personal wealth of her own as well, in excess of the joint assets she'd received by survivorship, and her entitlement under the will. But we can't know that for sure because there was never any disclosure from Nalini. So yeah, I think that's my answer.
Okay, yeah, that's interesting. And another thing that always I always think about in adult child claims is, you know, is there a standard? What one wonders with their sort of, the standard 50 grand for the adult child. Why do you think your client did better than Mrs. Eilert, for example? I mean, these things are fact sensitive, and that's probably the answer. But breaking it down a little bit, do you have any thoughts about that?
Well, I think what comes across from the judgment is that my client's mental health problems and her needs in relation to that really focused the judge. That's what he focused on in the judgment. His main aim was to make that the priority in the award. So I think that was an additional factor. We weren't just an impecunious adult child, the re-Coventry type of adult child claimant. There was something really quite particular about Sheila's case that needed provision.
So would you go as far as to say, do you think that an applicant with mental health problems is necessarily always going to do better than one who doesn't?
No, I don't. I certainly don't. I hope that wasn't what.
No, I was baiting you. I was completely baiting you.
I think no. I think the Act it requires these cases to be dealt with on a case-by-case basis, that you have to balance all the Section 3 factors. And it's not all about the claimant. Defendants' situations, their financial position or their health, physical or mental health issues are taken into consideration, as well as the obligations and responsibilities of the deceased and any other relevant factor. So I don't think there's a way to, I don't think there's a formula for a successful 75 Act claim, or a form, if you're X type of claimant, you'll get more than 50 grand or not. I think it does always come down to the individual case.
Yeah, I think that's why these cases continue to be so interesting on the one hand, challenging on the other. I think my sort of final thoughts about this type of litigation, now we've got a Court of Appeal decision on the CFA success fee aspect of things, is twofold really. One, as I said, is this going to make it a little bit easier for applicants to say, well, I've quantified a debt in terms of a CFA success fee now, so please let me have some of that, but also please can I have some of my inevitably irrecoverable base costs that I can't quantify yet exactly, but they're bound to be the order of.
I mean, at trial, you can quantify. I think, or at least the way I try to run directions in 75 Act claims, is there should usually be a round of updating evidence shortly before the hearing, because the Act requires everyone to take into account financial resources and needs as at the date of the hearing, as opposed to when the proceedings start. So I think as to kind of the timing issue, whether they're future costs or not, I think generally at trial you're going to be able to calculate what your success fee is. I suspect on the success fee point only, if you want to be successful in claiming your contribution to your success fee, you're going to have to provide the court with full and proper information as to exactly what the uplift is. The court probably needs to be satisfied as well that the success clause will have been triggered by the award that is being made. And you're going to have to provide some evidence now as well, going to King LJ's factors as to whether you really needed to enter into a CFA in order to fund this. I mean, a really interesting point is the interrelation between Section 5 interim orders and CFA and CFAs. I could bore everyone with the case law about the Section 5 orders, but what's really interesting is it's apparent that you can make a Section 5 application saying, I can't afford my legal costs to fund the claims, so can I please have some interim relief by way of some money to pay my lawyer's costs? And the court will at will, or depending on the exercise of discretion, see that as a legitimate basis for a Section 5 order. And they're really draconian orders because they're forcing the estate to pay out the costs in advance to a claimant to use who may not be successful or may not have a very high value claim by the end of it when there's a final determination. Whereas you would have thought that it would be preferable for the defendants for a claimant to be acting on a CFA instead of making Section 5 applications, because then the risk of losing is on the claimant's lawyers and the claimant themselves. But the flip side of that is that I think, particularly if the courts are going to, and they do in some cases, encourage claimants to go on CFAs rather than making Section 5 applications, I think it follows from a policy perspective that it is right, there should be the potential there for a claimant to recover a contribution towards that uplift.
Yeah, I'd agree with that. I think that my final thought is something I interrupted you about earlier on, which is whether we're going to, whether this case takes us a little bit closer, given the increasing numbers of judges who are expressing views about tensions between the different cost regimes, is whether in fact this takes us a step closer to a sea change in cost regime for particularly spousal claims under the 75 Act. I'm beginning to wonder whether we might not in future see an alteration in the entire regime that governs spousal claims. I think it would be difficult to and wrong to introduce it to all types of 75 Act claims, but there's at least an argument for a possible change in relation to spousal claims. I can see that.
Do you say it would be wrong to extend it to the other classes of applicant simply because there's not that marital relationship?
Yeah, I was thinking, it's much more appropriate in those sorts of claims to have the usual rule about costs after the costs follow the event, whereas in the matrimonial setting, arguably, I can see why you might want to align that more with the matrimonial regime.
I mean, the other argument, I think, is that it should be extended to all because of the statutory jurisdiction that's being exercised, which comes back to the point that I think feel quite strongly that 75 Act claims are just really different to any other type of civil litigation we deal with in terms of awards, damages awards. This isn't what the court's doing. So even if you're in one of the other categories of applicant under the Act, the court is doing the same exercise as it's doing under almost the same exercise as it's doing under Section 25 of the Matrimonial Causes Act. It's so similar. It's looking at a maintenance applicant's needs alongside all of the other factors to try and work out what reasonable financial provision would be. So I'd have thought that all of the applicants, it wouldn't just be limited to spouses, because it's this is a very different jurisdiction, isn't it?
It is, and it's not something we're going to be able to resolve today for our audience, Sophia.
No.
But we've run out of time. Thank you, everybody who's been listening. We hope you found that enjoyable, enlightening, even, and at least we hope you've found out a little bit more about the case if you didn't know about it already. Thanks very much, Sophia, for putting all this together for us. Well, we look forward to more 75 Act litigation soon, no doubt.
Thank you. Bye.
Bye-bye.